Good afternoon, everybody who is entering the room. My name is Michael Mayoral. I'm one of the founders and attorneys here at Perez Mayoral, PA. And today we're here to give you all a presentation titled Before the Storm, Florida HOA and Condo Property Damage Issues Every Owner and Association Should Understand. We're just going to wait about a minute more as we have a lot of people coming into the room now. Now, I realize that some of you may have some questions. There's not a CLE credit for this webinar. This is for homeowners. We do have CLEs that we give out, but in terms of questions, it's unlikely that we'll have time to get through questions really. I'm going to give you an email at the end of this if you have questions with regard to specific property damage issues to email us. And we do provide consultations on many of these cases, and we'll go through that as well, okay? But let's go ahead and begin with our presentation. Alrighty. All right, just bear with me just one moment. Alrighty. And you should be seeing our first slide here. Before the storm, Florida HOA and condo property damage issues every owner and association should understand. What homeowners need to know, presented by me, Michael Mayoral, I'm an attorney and founder of Perez Mayoral, PA. Okay. So before we start, I have to talk to you about it, and I'll give you a disclaimer. Everything that we talk about here is not legal advice. If you have a specific case or issue like that, every case is different. Every case depends on the facts, the law, what's in your governing documents. The point of this presentation is really educational. Okay, to provide as much information as you know, dispel myths, and really to equip you all with as many tools as you can have going into this hurricane season and really throughout your life as owners and associations. Okay. Why hurricane seasons create disputes? Because many times this is one of the biggest issues in associations, deferred maintenance or associations not doing the proper maintenance. Hurricanes really exacerbate these issues and make a lot of things come to light and create a lot of problems for people. This webinar is for homeowners who need to understand their rights, and some of you might be on the boards of associations, and we'd like to give associations advice too to manage risk and for anyone seeking to avoid costly disputes. Now, some information about us. We do not represent associations. We only represent homeowners, as many of you may know. That is our practice, that is our focus in the state, and that's really our passion. We practice throughout the state of Florida. We currently have offices in Miami, Coral Gables, and Tampa, with new offices opening this year in Palm Beach, Fort Myers, and potentially Jacksonville as well. So we practice all over the state and we handle these property damage issues for homeowners everywhere. And you'll see this, we're one of the few Florida law firms focused solely on representing homeowners, never associations. In my opinion, we're the best law firm that does this for homeowners. So today's topics, we're going to go through the introduction, which we just went through, our framework, common damage claims, who's responsible. That's the most, number 4 there, who's responsible is the most hotly debated issue in all these disputes. Insurance issues, action steps, best practices, ways to resolve these cases, and some hurricane preparedness, okay? So as I said before, who are we? We represent homeowners and floors exclusively, never represent HOAs or condominium associations. Not now, not ever. We just have a very specific practice. Nothing against the attorneys who do that, but we focus solely on homeowners, okay? And what do we do? HOA and condo litigation, everything from fines, enforcement actions, selective enforcement, board misconduct, governance disputes. We handle a lot of property damage claims, roof leaks, water intrusion, pipe bursts, mold, structural damage. We handle record and assessment disputes. We generally handle real estate litigation in general, both on the small, commercial landlord tenant, all the way to lawsuits, appellate cases, federal cases having to do with large multifamily properties, developments, and we handle business law and commercial litigation as well. But really, our focus is within the real estate litigation and really representing homeowners against their HOAs and condo associations because there's such a lack of attorneys who do this, and it is our passion, and we're well trained and capable of doing it. So let's start first with understanding the basic legal framework. And what I want to go into, this is all to answer the question, which is so often asked and so confusing for a lot of homeowners. Who's responsible for what? And what do they have to do? Okay. Really, it depends on what type of association you live in. Now, everyone in Florida, from judges, board members, and others, refer to their association as their HOA. It's very common to say my HOA did this, my HOA did that. People even say I have to pay my HOA with regard to their assessments. But in a strict legal sense, an HOA and a condominium association are two different legal entities. An HOA is a homeowners association and is governed by Florida Statute 720. Typically, when you have an HOA, it's typically single family homes, sometimes townhomes, okay? But typically, the key characteristics of an HOA, as opposed to a condo association, is within an HOA, owners maintain their own lot and homes. Many people will say, I own the home in fee simple. What does it mean? You own the home, you typically own a lot as well, and that's recorded on a plat. A plat will show the actual dimensions of your home, the boundary lines, and you can pull that from the property appraiser's office. Within HOAs, when it comes to maintenance, really an HOA is responsible for maintaining everything that's not on the lots, like common property, generally speaking. And with regard to things they have to maintain in the home, with regard to the structure around a home, that really depends on the governing documents. There are some HOAs where the association doesn't have to maintain anything on the home. We still see property damage claims there. Sometimes trees will go into people's homes and destroy the roots, and an HOA is responsible for maintaining a tree, which may not be on someone's lot, but there's still liability there potentially. Sometimes within the land itself, land is graded improperly. You'll have a home and the land next to it will be higher and will send water into that home. So sometimes an HOA, even though they're not responsible for maintaining the home, can be liable if they fail to maintain the property and that causes damage to a home. Okay. Typically, a lot of other issues you see with HOAs are ARC approvals and that type of issue. That's a lot of what HOAs do. And HOAs are governed by CCRs, is typically what it's called, Declaration of Covenants, Conditions, and Restrictions. Now, condo associations are a bit different. You have more rights to maintenance when you live in a condo association. Your condo association is typically a multifamily building. Just like in this slide, you see that little photo there of a building with many windows on it? That's your typical condo building. And how does it work? Essentially, you are supposed to maintain everything in the inside of your unit, and the association is supposed to maintain, repair, and replace common elements. What are common elements? Generally speaking, it's everything outside of your unit, but within the declaration of condominium, there's some wiggle room there. Sometimes we see people ask, is a window a common element or not? That's really going to depend on your governing documents. I'll go a little bit into that. Your condominium is governed by a declaration of condominium. That is what the governing documents are called. When people say the declaration, that is the governing documents that controls who's responsible for maintaining what, who has to have insurance, on what exactly and what amounts. Many times people refer to that as my bylaws, our bylaws, but really, if you're in a condo association, it's the declaration that controls, and your association is responsible for maintaining common elements. If you have an HOA, it's the CCRs that control, and your HOA may or may not be responsible for maintaining certain things attached or pertinent or related to your home. Key governing concepts here, these are things you'll want to know, and sometimes these words get thrown to homeowners and they're confused, and it's important to know. Okay. Common elements. A lot of this is going to focus on condominiums because you see a lot of maintenance issues there, but common elements, that is defined as everything outside of a unit, everything not included in a unit, generally speaking, unless the association specifically within their declaration ties something to a unit. There's many declarations sometimes that say, we will maintain common elements, and that is everything that's not included in your unit. And then there'll be a pipe in a wall, and a homeowner will think, well, that's not in my unit. Am I supposed to maintain that or the association? Because if a common element is everything not included in the unit, sounds like the association should maintain that. In the case of a pipe, it actually depends. Some declarations make a pipe that feeds water to only your unit, a part of your unit, without regard to where it's located. The declaration will say that. It'll say, A pipe is part of if a pipe feeds water only to one unit, it's considered part of that unit and the responsibility of the homeowner without regard to where it's placed. What's important is that that's not a standard rule across all communities. Many times we see associations tell this to homeowners. Well, if it's a water line that feeds only your unit, it's your responsibility. That's not necessarily true. It really depends on what's in your declaration, okay? But other typical common elements is the structure of the building, the roof over the building, common pipes, a common sewer stack. It's almost always a common element. What are limited common elements? Parking spaces, balconies are a big one. Balconies, terraces. Your association may define part of what you consider your unit to be a limited common element. What does that mean? It's exclusive to your use, and you may or may not have to maintain it. Some declarations say that the association maintains limited common elements. Other declarations say that a unit owner shall maintain limited common elements. That's going to depend on what's in your declaration. Unit boundaries. These are defined in your declaration. So what's a unit boundary? Everybody, there's a common, I don't want to say misconception, but if you ask people within condos, who own a condo association, what do you own? Many times people will say drywall in. Well, we all know it's drywall in, that I own drywall in. I would say that's true 90 to 95% of the time, and you really have to be careful to define what drywall in is. Typically, in most declaration, and I mean the vast majority of them, you actually, as a unit owner, do not own the drywall that makes up your ceiling. You don't own the drywall that makes up your walls. You don't own the slab below your tile. If you look into your declaration, most declarations will define your unit as the space between the unfinished surfaces of the walls, ceiling, and floor. What does that mean? It means the drywall that's part of your ceiling is a common element. What does this ultimately mean in a property damage case? If you have a leak above you caused by your upstairs unit owner and your drywall on your ceiling is damaged, your association has to fix that drywall no matter what the cause of the damage is, because that drywall is a common element. So I instruct clients and people who I consult with, you need to think of your unit as the cube within the drywall. If the drywall is messed up, you need to tell your association, you need to fix that. I don't care whose issue it is. That's a common element. You repair it. If it's coming from above, you, association, figure out what's causing the damage to the drywall. And we'll talk about that a little bit more. Incidental damage. What is incidental damage? Within some declarations, within some sets of governing documents, there is a clause called an incidental damage clause. This clause is really important to figure out if it's there within your declaration. Most of the time, you will find it in the section of your declaration that speaks about who shall maintain what. If there's an incidental damage clause, usually it'll be in the section where it talks what the association must maintain. And it'll look something like this. The clause will say, the association must maintain and repair all common elements and also must pay for at its expense all incidental damage caused to a unit by those repairs. What does that mean? If your association has to go into your unit and break up your tile floor to get to tension rods to repair those, they are on the hook to pay for your tile floor to replace it. I don't want to give you a news flash but associations will not tell you about this. I have never seen it. I have honestly never seen an association inform their unit owner that we have to pay for that because we have an incidental damage clause. They just won't. So it's something you're going to have to figure out and find there. Many cases we handle are based on incidental damage because there is case law, legal opinions that also provide that not only does an association have to repair the incidental damage to your unit, but they may have to pay for alternative living expenses, lost rent, or any financial damage to you caused by their repair of common elements. So this is really important to know about, that your association, if they say we need to take over your unit and destroy it because of common element repairs, they may be on the hook for all of that, okay? All right, and we've already spoken about association obligations and governing documents, and we could go into the next slide. So most common hurricane season claims that we see, okay, we see these claims all over the state. We currently have hundreds of them in litigation. We have a division within our law firm dedicated to suing condo associations and other unit owners sometimes for property damage to our units. And we see these claims quite a bit, quite a bit. What is the most common claim we see? I want to say hurricane property damage claims, but these are really common claims in Florida. We get hurricanes every 2 to 3 years, so it's a continual process. What do we see in associations? Roof leaks. It is the most common issue we see. Why? It's expensive to replace a roof. Associations are very bad, generally speaking, with regard to responding to maintenance claims. So many times we see roof leaks damage multiple units, and associations will delay replacement. They'll put temporary patches up that fail, and you'll see repeated water intrusion and interior ceiling damage. We sue associations for this every day. And every case we have started out with the association telling our homeowners that they were not going to pay for any damage, that the homeowners are on the hook for all of it, the homeowner should make a claim with their own insurance. We sue condo associations for this all of the time, and we are highly successful in it. I'm going to go into the reasons why and what associations do to try to get out of these claims, but we see those all the time. Windows and sliding doors. Windows is a big source of water intrusion, sliding doors too. This is a good clue to know if a window is causing property damage in a condo association is this. If a window above you is causing property or a water intrusion, you're usually going to see a leak on your ceiling right below where that window is. If you're living in a condo, most of the units are built in lines of units that are very similar. So if you're looking at your window in your unit and you see brown water stains right above that window, there's a good chance the window above your unit is leaking. Conversely, if the unit below you is experiencing water stains below your window, there's a good chance your window might be leaking. Okay. The question of who is responsible for windows, for the maintenance of windows, depends on essentially a lawyer analyzing your governing documents. You might be able to analyze the governing documents and it might tell you who's responsible for maintaining windows. Sometimes it requires a little bit of a deeper analysis. But windows are something, and windows and sliding doors are not automatically a common element. They are not automatically a unit owner responsibility. It really depends on your governing documents. If your association is telling you that the window is your responsibility, or really anything is your responsibility, it's a good idea to ask them, can you point out within our governing documents where that is my responsibility? I have seen so many cases where I know that the board and the property manager who was telling my client something about who was responsible for what had never read the governing documents at all. So really, that's where the smoking gun usually lies. It's within the governing documents itself. Exterior walls and stucco, very common source of water intrusion, very easy for it to get by. Buildings and boards might think, well, we have to maintain the roof, we have to respond to water intrusion if we hear about it. Many times they don't think about the stucco around the building. Why are there stucco failures? A number of reasons. If a window starts leaking, putting water into the stucco, that can weaken the stucco further. And by stucco, I mean the exterior concrete or material on the outside of the building. There's cracks that get into that many times cause water to enter into units, okay? So that can cause long-term hidden moisture, long-term and big mold problems because it's not an immediately detectable leak. It can go on for quite a while. So don't ignore stucco leaks, cracks in the stucco, okay? Pipes and plumbing failures are really common disputes that we have. Okay, many of our cases are pipe bursts or sewage overflows, sewer stack overflows. What happens? Associations are responsible for maintaining many of the pipes within a building. Associations typically just do not do any preventative maintenance on pipes at all whatsoever. It sounds like an overstatement, but it's really not. How we prove most plumbing leak cases is we ask the association for any evidence they've ever maintained pipes, and lo and behold, there's none. Why? Boards typically they react. They're not proactive. They're waiting to see if there's a complaint and then addressing that complaint. Many of the issues we see, the first floor unit owner will get backups from the sewer stack, or a pipe will burst, or there's a pipe leak, or a water pipe will leak. What you have to know about pipe and plumbing failures, if it's a common line, like a common sewer stack, the association is almost always responsible and many times is liable and will have to pay for the damages to your unit. If it's a water line that only feeds a unit, usually I'd say 60% of the time a unit owner will be responsible for that, but about 40% of the time the association may still be responsible for it. If you really want to know my opinion on it, it has to do with the age of governing documents. Older governing documents, how I have read them, and I read through a lot of declarations every year. The older ones made in the 60s and 70s, typically they weren't anticipating so many lawsuits and property damage issues, so they just made associations responsible for all the pipes and plumbing. And the newer governing documents will really draw this line and say if it's a water line that only serves your unit, you are responsible for maintaining it. It all depends, all these cases depend on what the source of the damage is and what the governing documents say with regard to who's responsible to maintain it and who's responsible for the damage it caused. It depends. Okay. And mold and habitability. Mold makes units very unsafe. It's not great for health. It's terrible for children to be around. It's terrible if you have a suppressed or compromised immune system. Generally, associations will ignore it. Homeowners should not. And homeowners should demand mold remediation from their associations. Many times, let's say a situation where a pipe burst, an association will tell a unit owner, well, we're going to go down and don't worry, we're going to send our maintenance person and he or she are going to fix your drywall. We're going to patch up the drywall. Well, what about the mold? What I see associations not doing is hiring somebody to do a mold test and determine if mold remediation needs to be done before they seal up the drywall. Many associations will either just replace the drywall or just paint some what's called Kills primer on it. It's a type of primer that's supposed to protect and stop, mold intrusion to a certain small extent. So it can be an issue and something that should be demanded from associations. If they're doing water remediation, they should be investigating for mold. Water in trapped dark spaces and the Florida humidity causes mold. Now, who is responsible for damage? So, this is really my passion area. I don't want to overstate it, but I really love suing associations for property damage. Why? They really get away with murder in this state. Not literal murder, but they get away with really causing a lot of damage, not paying for it, not fixing it, and leaving homeowners in an absolutely terrible spot. Okay. So I'm going to try to give you all the intro for who's responsible for property damage in condo associations. This is the opposite of what your property management company will tell you if they're being dishonest with you. Okay. So per statute 718.113, doesn't matter what's in your governing documents, but per the statute, associations have a non-delegable duty to maintain, repair, and replace all common elements. What does that mean? If the association says we're waiting for insurance money for repairs, that's not an excuse. Per the statute, you have to repair this. You need to get to it and repair it. If the association is saying, well, that your drywall, your common element drywall is moldy and dirty, but we want to sue the upstairs unit owner and see if we can get money from him or her before we repair it. That's not an excuse. Why? The Florida statute says the association is responsible and has the duty to maintain, repair, and replace common elements. The statute does not say it has the duty to maintain common elements if it's easy for them. They have the duty to maintain common elements if they happen to have enough spare money. No, they have to do it. It's a duty that if they don't do it, they're in breach of it and you could sue them for it. So, like I said before, what are common elements? Roof system, exterior walls, building structure. And within the boundary, remember that, and this is a key thing here, associations will play this game. Okay, what they will do is say, and I'm going to go over this later, and this is possibly the most important part of the whole presentation. Okay, you are facing property damage. You may face it, you may not, but you might have a leak in your unit, you might have pipe burst in your unit, you might have the association causing the damage, and your association will tell you, well, as you know, homeowner, we maintain the common elements, and you are supposed to maintain everything in your unit. Therefore, we will fix the roof, and you fix your unit. Sounds like a deal, right? And many homeowners will say, well, that sounds kind of right. Within the declaration, I am supposed to maintain everything in my unit, and they are supposed to maintain common elements. So why should they have, how can I make them pay for the damage they caused to me? The difference is between responsibility for maintenance and liability and fault. Let me give you an example. I have a car. Many of you have cars. If God forbid today you're at a stoplight and I rear end you, I get in a rear end collision with you, crash you from behind. Normally, I'm at fault for that accident, as we all know. The person who rear ends somebody is at fault. Now, imagine me getting out of the car and saying, well, John Doe, listen, I have insurance on my car and you have insurance on your car. And, I'm supposed to maintain my car normally and you're supposed to maintain your car normally, correct? Therefore, you maintain your car and I'll go fix my car. Since we're supposed to both maintain our cars, you can maintain yours, I'll maintain mine. You would say, no. Yeah, of course, we're supposed to normally maintain our cars, but when you were negligent and crashed into my car, you are now at fault. And if you don't pay me, I will sue you. That is exactly the situation when an association fails to maintain a common element and it damages your unit. Yes, you were ordinarily on a regular day, you were responsible for maintaining your unit. And yes, the association is responsible for maintaining things like the roof. And yes, you're supposed to have insurance on your unit, just like they are. But when they fail to do it, when they breached their duty, they are now liable or at fault for the damage. What we do as attorneys is go to them and either sue them or demand that they both do the repairs to the common elements and they pay you for all consequential damages caused by their breach. What does that mean? Out of pocket expenses that you've spent so far on fixing it, future costs of repairs, getting an estimate for everything, mold remediation if necessary, alternative living expenses. If they've wrecked your unit and you can't live there or you lose a tenant, they're responsible for that damage too. They're liable for it, at fault for it. Now, are they going to tell you, hey, we are at fault for all this, you could sue us for all this? They are not going to tell you that. Most associations, most bad associations, will try a number of techniques to get out of it. The first one is this: trying to tell you you're responsible for your unit, we're responsible for the common elements. Therefore, when damage happens, you each repair your own damage. That is not true. That is not the general rule at all. It depends on who caused the damage, what the source of the damage is, okay? Now, damage from another unit, who's responsible? And this is important to know as well. Why is this important to know? Let's say you are responsible for maintaining a pipe in the walls. Per the declaration, your declaration says, Jane Doe, homeowner, is responsible for the pipes in the walls. And then it's discovered that there's a pinhole leak in one of the pipes in the wall. You had no way of knowing it, and it flooded the unit below you. It flooded the lobby of the building, and they're sending you a letter saying, because of this pinhole leak, you owe us $50,000. Are you liable for that? Are you responsible for that? The law actually says not so fast. What the law says, and this actually applies to associations as well, is that there's no strict liability for unit leaks. And there's also no strict liability for leaks coming from common elements. What does strict liability means? Strict liability means you don't need to prove negligence. In all these cases, we need to prove what some people call negligence, or what some other people call a breach or a failure to maintain, a breach of the governing documents. Remember, your governing documents say you have to maintain everything in your unit. So let's say that pipe in the wall is part of your unit, and the association tries to say you're responsible for this. You could counter and say, no, I was not negligent. There's nothing I could have done to have stopped that pipe from leaking. I can't go into the walls and maintain them. There was no sign of it, so I'm not negligent. Therefore, there's no strict liability here. Therefore, I'm not liable. You have to be really careful with this because some associations who are fairly aggressive will just try to assess your account for it. We'll just put a charge of $20,000 or $30,000 on your account and say you're liable. We do defense on these cases as well. So if your association is trying to put the blame on you, or another unit owner is trying to put the blame on you, it's not so fast. They need to prove negligence. They need to prove that you failed to maintain something within your unit, and we could defend you on that as well. Okay. Sometimes you also want to be careful that an association sometimes might be blaming you for something that is not your fault at all. There may have been a common element failure, a window leak, or a roof leak, and they might try to blame it on your AC. This is part of the blame game, which I'll go into later, but you want to really be careful. The key point is if you're being accused of property damage as a unit owner, it's very technical to actually prove that against you, very difficult. And your best advice is to talk to an attorney as soon as you get that allegation or accusation against you. Like the minute you get it, before you start giving statements, really talk to counsel who could guide you through it, because many times the association cannot prove it, and we end up telling them you have to repair this at your expense, but my client's not paying for anything, and we're very successful in that as well. Okay. All right. Damage in your unit, who's responsible? Okay. Let's just go through some examples. Okay, and remember, the question is what failed? The text here reads, not all damage inside of your unit is your responsibility. The most important question is, what caused the damage? And who is responsible for maintaining that component that caused the damage under the declaration? So these are issues where this will typically be your responsibility. Let me go to that first so I can tell you these are things that if this happens, it's probably your responsibility. You should probably take steps to repair the damage and not create a huge issue about it because you can get sued for it. Okay. Damage caused by your water heater. That might be your responsibility. What I mean might, if it's a freak accident, you just got a new water heater that just explodes, there's nothing you could have done to stop that. You're probably not liable for it. Are you going to be responsible for fixing your own home? Yes. But you're probably, if it damages downstairs, that's going to be hard to prove. Now, if you have a really old water heater and you haven't replaced it and it's past its life, and the association can prove that, you're going to be responsible for fixing your own home and potentially the damage it causes. Same thing, but with an HVAC or AC system serving only your unit. You're typically responsible for that and the damage it causes. Damage caused by your tenants, guests, or occupants. We had a case where a tenant above our unit flooded the unit on purpose, potentially, just to damage the unit, and it damaged and it destroyed our client's unit. You might be responsible for the damage caused by your tenants. Many times within the declaration itself, it'll have a clause that says that. Damage caused by owner installed improvements. My wife handled a case where a doctor installed a tankless water heater and it burst and it caused damage to a penthouse downstairs, millions of dollars of damages. So you really want to, if you're installing something in your home or you're having a contractor work on anything really that requires a permit, my advice, get a licensed contractor, make sure they pull permits, make sure they do the job really well, make sure they have insurance, because if you don't do that and something goes wrong, you're going to be sued for the damage and they're going to accuse you of having done all this work without a permit. They're going to call the building department on you. It's going to be a big old mess. For all intents and purposes, only use licensed contractors and pulling permits, okay? Damage caused by your plumbing fixtures, we talked about that. Damage caused by your windows, we spoke about that. That may be your responsibility. Sliding glass doors, it may be your responsibility as well. Now, association responsibility, let's talk about the good stuff, okay? And this is really more common. There's not that much damage within a building caused by homeowners. Is actually kind of rare. Most of the damage is actually caused by an association failing to maintain certain things. So when is an association responsible? Okay, the first most obvious one, damage originating from the common elements like roof leaks, roof failures, exterior wall and building envelope failures, waterproofing failures, common plumbing line stacks and risers, structural components of the buildings, damage caused by association contractors. Again, folks, your association is generally responsible for damage caused by their own contractors. What Florida law holds is that associations are generally jointly and severally responsible or liable for the damage caused by their contractors if their contractors were repairing common elements. That's what a non-delegable duty means. It means that an association has a non-delegable duty to maintain the common elements. They could hire someone to do the job for them. Your board president doesn't need to repair the roof themselves. But if the person they pay to repair the roof damages your unit, your association, generally speaking, is jointly and severally liable. What does that mean? Your association cannot just tell you, go after the contractor. Really, the association has to, if they're smart, they would repair the damage to your unit because the association is just as much on the hook for their contractor's damage as the contractor is. This is something that will not be told to you, will not be volunteered to you. If any of you need the case that says this, you can email us and we could send it to you, okay? Incidental damage resulting from common element repairs. We spoke about that. If your association has to break into your unit to do repairs to the common elements and they repair and they cause damage to your unit, and there is a clause in your declaration that provides for expenses for incidental damage, then they may have to pay for that. Okay. And also additional damage caused by the association's failure to timely repair common elements. We'll talk about that as well, but let's say it's a case where your neighbor above you has leaked into your ceiling and your association has let this go on for a year. Your association at some point is responsible for the whole damn thing because they have a duty to maintain that common element drywall, to have investigated, to have prevented further damage. So many times we sue associations for that. It's one of these cases that really get to me. I hate when an association tells a homeowner, it's between you and the unit owner upstairs who's not answering their email, who's not answering their mail, who will not return a call. It really leaves our homeowners with nothing to do except call me, and then I end up suing the association rightfully, and we're usually able to get a good result for these people, okay? All right, and I put this here as well. What does the Florida statute hold? Maintenance of the common elements is a responsibility of the association. That's the quote from the statute. It's that clear. And I really put a note here. Florida law places the duty to maintain common elements squarely on the condominium association. When a common element fails, the association cannot avoid its maintenance obligations by arguing that another unit owner, tenant, guest, contractor, or third party caused the damage. What does that mean? Your association has to fix the common elements, which is your drywall, the space between the units, no matter who caused the damage. That's especially, going to hurricane season is something you definitely need to know. And one thing I would say, going back to the slide, remember we made the difference between condos and HOAs. There are many HOAs that function like a condo association. Usually the key part that's going to clue you off that it functions like that are shared buildings, multiple units in a building, a row of townhouses with 4 units. Typically, your association may have some responsibility to maintain the roof, sometimes the walls. So if you have a Chapter 720 HOA, it's tricky, but review your governing documents. Don't take their word for it. Really, the truth is going to be in your governing documents of who's responsible for what. So these are the 3 categories of damage responsibility we deal with: common element damage, damage from other units, damage from I was supposed to say you or your unit, my apologies. But we spoke about that of the responsibility. Remember, damage from another unit owner, the negligent owner, and the association may be responsible. If I could tell you another most important fact is this, I'm beating like a dead horse here. When there is a unit owner to unit owner leak, do not let your association wash their hands of it and leave it between you 2 or you 3. That is an abdication of their duty. It is they're really just not doing what they need to do. It's a violation of the law. Everyone needs to be called out on it, and there's a lot we could do in those cases, okay? McClellan versus Cypress Chase. Okay, this is one of those most important cases. All right, you could Google this. If you Google McClellan versus Cypress Chase, you're going to find an article written by our very own law firm on this case because it's so important. All right, and this has to do with what I just spoke about. So, what happened in the McClellan case? Sewage water poured through Mr. McClellan's bathroom ceiling from a blockage in the unit above. The association refused to repair it, calling a unit versus unit issue. Our appellate court in Broward County, which handles Broward and Palm Beach, reversed and said no, your association was on the hook here, no matter what the cause of the damage was. The association always had a duty here to maintain the space between these 2 units, no matter what the cause of the damage was. I say this because this is an extremely common factual scenario where many times people have leaks in their unit and the association is either telling them we're still trying to figure it out a year later, which is BS, or it's from the unit above you, deal with them. That's not what the law says. If you're a condo association, if they're saying that, they are in violation of the law. They can be sued, they can be made liable, and they have a duty to maintain the common elements regardless of the cause of the damage. And that's the quote from the case. The association had a non-delegable duty to repair the common elements regardless the cause of the damage. Key point there again, if you're having a leak from another unit, it's not just between you two. The association has a duty here. They need to jump in and fix the issue. Do whatever they can to remedy the issue. All right. Insurance issues during hurricane season, okay? Okay, so we're going to go into a basic breakdown between association insurance and unit owner insurance, okay? Many of you probably know this. I apologize if I tell you something you already know, but it's worth going over. Many people don't understand this well. Okay, when you are in a condo association, most declarations say you are supposed to maintain insurance on your unit. I would say it's a good idea to do it, also for liability coverage, just in case your water heater bursts. So if you get sued, your insurance company will defend you. But most associations require you to have insurance on your unit and the association to have insurance on the property, casualty insurance, just in case the whole building burns down, a hurricane knocks it down, or whatnot. Okay. There's a bit of confusion here sometimes. Some people believe they do not need insurance on their units because my building has insurance. That's not true. The building insures the outside. You have to insure the inside, okay? The big confusion is when damage happens, okay? Many times associations will try to pull this card of, well, whose fault is it for the damage? Let's look at who's supposed to insure what. Insurance does not determine maintenance responsibility or liability. If the association failed to maintain the roof and it wrecked and damaged your unit, you don't need to make a claim on your own insurance. You could just sue the association, okay? But associations will not tell you that. They'll say everyone should go to their own insurance, which may or may not want to do. But the common insurance problems we see going into hurricane season, and this is really for overall holistic preparation for hurricane season. Believe it or not, some buildings do not maintain property and casualty insurance. Why? They have failed to do so for many years, and now it's very difficult for them to be insured. It's not really common, not very common, but I have seen it more than once. We get probably I at least personally speak to at least a homeowner every 1 or 2 months who comes with this situation. My building president, my board president says we don't need insurance. He doesn't want it. That is a terrible practice to do. What I tell every one of those homeowners is that you all need to recall the board immediately and go do whatever you need to do to get the building insured. Why? Number one, God forbid a fire happens, everyone is going to just lose all of their property and everything and just lose their whole investment. If a building burns down and there's not insurance to reconstruct it, how are you going to reconstruct it? Okay. Generally speaking, you could just wreck all the homeowners of it. Second thing, hurricane damage. What if there's flooding? What if the roof gets torn off? What if we have to repair common elements? What if there's $1 million in damage to a building with 15 people in it? How much are we going to assess everybody? Hundreds of thousands of dollars or tens of thousands of dollars? That creates issues there. Also, units become impossible to sell to people with conventional financing if there's no insurance on a building. The Florida statute was changed in the past couple of years to require associations to maintain insurance. So if your board president is saying, no, we're not interested in getting building insurance, you could actually sue them to compel them to do so, but it actually happens. The other problems and faults we see is once a loss happens, an association will mismanage the repairs. They will mismanage the insurance funds. They'll mismanage the whole project. And typically what we see is my board got $2 million in insurance funds. They paid the contractor $2 million upfront, and the contractor ran off with the money, or did some of the repairs and is going bankrupt now. Or the contractor kept on adding change orders. They blew up a $1 million project into $4.5 million, and now we all need to pay these massive special assessments. I'm going to give you the 60-second or 30-second answer to what's going on here, what needs to be done. When an association of any size really suffers an insurable loss and has to do any form of significant repairs, those repairs should not, generally speaking, just be managed by the board. Why? There's no requirements or qualifications to be on a board. A whole board or a board president may have experience in negotiating contracts, lo and behold, most of the time they have absolutely zero experience in negotiating contracts of any type, terms, which are tricky, managing a construction project, being able to analyze a contractor's proposal. This isn't just like repairing a kitchen. This is repairing a whole building. Are you being fleeced as an association or not? Because it's Florida and there's many contractors who will fleece associations. If they catch an association who's not sharp, who's not negotiating a contract, who just says yes, signs off, and is not monitoring a project, there's an unscrupulous contractor, you're going to see change orders, you're going to see increased costs. The sky's the limit to bad things that can happen. What should an association do? Hire someone to manage the project. There are many people who do what's called owner representation, who will be a third party and will manage that construction project for you. They'll analyze the contracts, the insurance proceeds. They'll be shrewd. They'll be shrewd as hell about it to make sure you're not getting ripped off. You could also, sometimes a property management company will sometimes say, you could pay us to manage the project. I don't always recommend that. It depends on the property manager. I would ask for their qualifications if they've done that before, because they can be tricked just as easy as a board can. Many associations form what's called a construction committee. And that committee, say you have a building full of 500 units, many times the unit owners are attorneys, contractors, engineers, and they could form a committee to analyze all of this. The worst thing to do is, boards are really trying to help. I'm not too cynical of a person. I really think boards are trying to do the right thing a lot of times, but they're not really equipped to handle that. I'm an attorney who does all of these cases. I've handled large multifamily lawsuits, appellate federal courts, huge cases, small cases, doing contractors, construction. I shouldn't be negotiating a contract like that, knowing what I know, and I know more than your average bear about this stuff. But I would ask somebody else that you need to form a committee of actual professionals to analyze this, not just me. It's all going to look the same to me. So that's to be said. Insurance claims can go haywire for a lot of those reasons. Best practices: create a construction committee, hire an independent manager, get multiple contractor bids, closely monitor insurance proceeds, verify contracts, change orders. Do not assume the property manager can run a large scale restoration. And if you are all homeowners in the dark and this is being mismanaged, recall the board. In Florida, you could kick the board off at any time if 51% of the homeowners agree to it via ballots. You could turn in 51 ballots comprising of 51% of the homeowners, and you could kick out the old board, put a new board in, and fix and right the ship. Fix it so that your association is not losing money through its nose, okay? And remember, even though there's insurance and insurance proceeds, if your association is saying, we want to do repairs, but we ran out of insurance money, they're not off the hook. They still have to repair the common elements, the white box, and everything. It sometimes becomes an issue because where are they going to get the money from? But either way, they're on the hook, and you really need to light a fire underneath them, okay? So what should homeowners do immediately after damage? Okay, document everything. Okay, photograph and video all damage immediately. You will be surprised of the things you will be accused of lying about. If there's a flood of water into your unit, photograph it, videotape it. Later, the association may tell you, we have no evidence of water ever going into your unit. And you'll say, the board president saw it. The management person saw it. What do you mean? They'll say, we have no evidence. Videotape it. Every time there's water intrusion, you have your phones, take video, take photos, okay? Notify them in writing so they cannot say they didn't hear about it. What I would notify them, I would say, I believe I have damage to the common elements of my unit. I'm demanding full remediation of my common elements and a fix, and I want a response by the end of this week, whether you're going to agree to do it or not. Mitigate damages, okay? Inform the association so they have the right to inspect, but you need to mitigate your damages in some sense. What does that mean? If you can prevent further damages, prevent them if you can, okay? What does that mean? And really mop up water, try to stop a leak to the most you can. If you have a tenant that they're saying, hey, there's a leak, water's coming through, go there, try to stop it, try whatever you can to stop damage. Preserve evidence, that's what I spoke about. Obtain inspections. Many times your association will tell you, we cannot find the source of the leak, we don't know where it is. You could hire your own independent person to find the source of the leak, okay? If the leak is occurring above your unit, like say your bathroom ceiling, a contractor can open up the drywall, point a flashlight up there, and usually, a plumber can usually find the source of the leak pretty quickly. It's either going to be a P-trap, a toilet ring, or something like that. But also from the outside of the building, you could hire your own independent leak inspector or engineer to investigate in case the association is giving you the runaround. And overall, if you're facing water intrusion, you're going to want to find out the source, even if you plan to sue or not. So you could just stop the water intrusion. If you ever want to sell your unit, if you need to, it's very difficult to sell a unit with active water intrusion, if not impossible. So there are people out there who could find the source of that, and expert opinions matter. It's an evidence-based justice system. That means to sue an association, to sue another unit owner, the first thing I will ask you is, how do we know what the source of the damage is? It cannot just be that's what it seems like. We have to really know, okay? Many times you don't need an engineer. If you're at the top of the building and the roof is leaking on you, we know it's the roof. But other times you might need a plumber, a leak inspector, someone to determine that. If you look up leak detection companies, many times these companies will do it for $400 or $500. We'll go out there and try to find the source of the leak for you. And track all of your costs. Okay, track all the costs of what you're spending. Keep receipts for everything. So what should associations boards be doing? Okay, best practices. Okay, rapid response, post storm or post any loss. Have pre-approved emergency vendors on call. Prompt inspections and documentation when they hear that a loss has occurred or damage has occurred, and communicate with your homeowner. Most clients call me and calling me because their association just simply stonewalled them and they weren't getting anywhere. They're at their wits' end, so they call me and we're able to get them a result. Is there litigation exposure against associations for this? Absolutely yes. First of all, these cases carry prevailing party attorney's fees. So if I sue an association, they have to pay for my client's damages and for their attorney's fees as well. Associations are responsible for consequential damage. If there's a board member who thinks it doesn't matter what we repair because unit owners are responsible for everything in their unit, no, no, no. If you fail to repair a common element or maintain it and you damage the unit, you, the association, are responsible for all the damage, are liable potentially for all the damage caused. Okay, there's habitability and displacement claims. You could be sued by a tenant for causing mold related injuries, mold related property damage, and you can be sued generally from owners as well. It's what we do as a law firm. So associations should be really jumping on these claims immediately and trying to stop the damage immediately. Many lawsuits associations could have saved thousands of dollars by just paying for a little bit of repairs, just a little bit of drywall, a little bit of stucco repair on the outside, and they don't, but that's what we are here for. Okay. So pre-suit resolution, avoiding litigation. The issue with this is that, spoiler alert, is what I meant to say. There's many times not too many ways to avoid litigation. In my experience, you either have an association who's doing it completely right, and those homeowners never call me, or the other ones who do this game. Okay. So what is the game? And this may seem cynical, but I can certify to you that I have heard this from hundreds, if not thousands, of homeowners facing property damage. I have a video on this. I see the same exact pattern across thousands of cases. Someone will call and say, association, I have water intrusion into my home. I'm having molds from the roof. What will associations usually do first? Bad ones, they'll deny the problem. They'll say, we don't see any damage. It's normal wear and tear. You don't have enough information. We think your AC, you keep it too high, so lower your AC, some nonsense like that. Once you're usually able to show them there is water intrusion, many times what to do is to blame you, the unit owner. I think we think you keep your AC too high. You didn't report this to us on time. It's from your unit actually. Maybe it's from your plumbing. Maybe it's from your window. Without even actually determining this, they'll just blame our unit owner, or they'll blame a neighboring owner, and they'll say this is between unit owners. They'll refuse to investigate the source. Then they'll try to shift responsibility to insurance. They'll say, well, there was a loss, but call your insurance company. As I said before, if they're responsible or liable or at fault for the loss, you can call your insurance company if you want. You can, but they're also reliable. You can sue them for this and make them pay for all the damages. Also, your insurance is usually not going to pay you out for a slow roof leak. Insurance, homeowners insurance, is made to pay for sudden events, pipe bursts. If it's a slow window leak, slow roof leak, you're probably out of luck with your own insurance, okay? All right. They many times will misapply the declaration, okay? They will point out, like I said before, they'll say, look, you're responsible for maintaining your unit, so why don't you fix your unit and we'll fix the roof that damaged your unit. That is intellectually dishonest at best. At worst, it's grossly negligent. It's just outright ethically and morally wrong to misinform somebody like this. And I say that because I've seen senior citizens in their 80s being told this lie by associations, and it really grinds my gears. Okay, they will delay the repair process. Many times it's the last step. They'll say, fine, we admit it, it's our fault, we're going to do repairs. We're looking for contractors for 18 months, 24 months. They're still looking for contractors. We sue associations at that point as well. What are the consequences of delay? Rain, moisture, mold, and then hurricane season. I represent some people whose homes still have water intrusion, and the association has not repaired it going into hurricane season. What's going to happen? What's going to happen to that person's home during hurricane season? It's going to be flooded. And the last thing is that these units become impossible to sell. If you have active water intrusion, they really become impossible to sell. So what should homeowners do? Find the source, like I said before. Document everything. Put the association on notice. If you don't want to go with an attorney to handle this, you can make your own demand. Say, I want you to repair this in a week, and if you'll agree to it, and escalate when necessary, okay? And this is not to push my services, but this is what I see most often. Associations really don't, generally speaking, the bad ones will not do the full extent of the repairs unless they're faced with a credible threat of legal action. You could absolutely try to get the repairs done by yourself, and I wish you all the best of luck. And I hope that you don't need an attorney to do that. I hope your association's great, but that's not what I see in the state of Florida. I see associations, if they agree to do something, they're really agreeing to like 10% of what they're really liable for doing, and many times they don't even get there. They drag people along for years until the statute of limitations run. Okay, so hurricane preparedness for homeowners, review your coverage, okay? Make sure there's insurance on your building. Make sure you know your emergency shut-off locations if there's a pipe burst or something like that. For associations, test your emergency communication systems. So one thing's have an emergency line for people to call if something is happening, okay? And there's common questions and answers, but we're running out of time. The one thing I would tell you, I just want to tell you about us a little bit before we go into here, okay? On these cases, this is the third most important thing for you to know as a condo unit owner in Florida. Our firm, Perez Mayoral PA, we offer free consultations on specifically these cases. We do not offer free consultations on every type of case. There's so many, there's no firm who could have the volume to field all those calls. But for property damage caused by the association or by a unit owner, we offer free consultations on those cases. So if you have a leak, a pipe burst, a roof leak, something like that in your unit, call us. We will analyze the issue for you for free, no charge. It'll be a great conversation. I'll tell you who's responsible, what we could do. Even if we can't sue, I'll give you great advice, okay? And what do you need to know? We many times take these cases on a contingency basis. If it qualifies, there's significant damages here, we could take these cases on a contingency, which means you don't have to pay for legal fees up front. I could sue the association, they could fight me as hard as they want, and I will keep on going at them until we get a resolution for you, okay? And all other disputes, we generally do an hourly retainer for, and that many times we're able to get attorney's fees back for those too. So even if it's a case where we can't do it on contingency, we are highly successful in these property damage cases. We're usually able to get full repairs done to the inside of the unit, attorney's fees back as well. This is the third most important thing. We are your friend when it comes to property damage. I implore you to tell your friends, anybody who's facing these issues. I really like helping people with this. It's really a mutually beneficial thing for us. It helps our firm grow. We get to, we monetize these cases and get you as much as possible, but it gets repairs done for people. We've done this for hundreds of people, gotten the repairs that were denied for years to be completed, got compensation for them. It's some of the proudest work I have in my whole legal career is what we do on these cases. So if you enjoyed the webinar, we'd be grateful if you took a moment to leave us a review. If you don't get the QR code right there, you could also find us on Yelp or Google or leave a review. Now, we couldn't get into many questions, but if you have a question about a property damage case, you could email kzamora at pmlawfla.com. If you have a property damage case, you say, I'm ready to consult with you guys tomorrow, call us. Tell us what the case is about. Tell us it's about the property damage to your unit. You'll send documents in. I or one of our attorneys will meet with you and we'll figure out what we could do to help you. But if I could leave you with anything, it's to say when damage happens to your unit, take it seriously. You own property. Your property shouldn't lose value because of someone else's damages. And there's a firm in Florida that is dedicated completely to helping you with these cases. And it's our firm, Perez Mayoral PA. I'm Michael Mayoral, one of the founders. I'm very thankful for you all taking your personal time to meet with me today. Again, if you have any questions, reach out to us. If you have a potential case, reach out to us. We'd love to talk. And thank you again. I look forward to hopefully meeting with each of you soon. And take care and have a very safe hurricane season and a wonderful day.